amendment to engender fair trial provisions as proposed in the committee's amendment. Appointment of the presiding officers and members of the courts martial. Right Honorable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the bill
129 or 128?
I beg your pardon. Guaranteed under Article 128 of the Constitution. While the bill amends qualifications by requiring legal training for the presiding officers, committee expressed significant concern over the appointment process. Currently, all members are appointed by the High Command from a list it generates in consultation with Judicial Service Commission. This system grants the High Command broad powers to appoint members for specific trials, raising serious doubts about the members' independence and vulnerability to external influence. The idea of consulting Judicial Service Commission does not explicitly define the role of Judicial Service Commission in the process of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure for chairpersons of court-martial, but is silent on the terms of other members. The committee noted that secure tenure is vital for judicial independence, safeguarding judicial officers from arbitrary removal of political pressure. A 3-year term is inadequate, and unclear removal grounds for members create insecurity, risking impartiality. Citing Justice Asaph Ruhinda-Ntenje and another versus Attorney General, Constitutional Petition number 33 of 2016, which declared fixed term contracts for 5 years for all members and the defining grounds for removal to protect judicial independence. The committee recommends that a term of all members be increased from 3 years to 5 years and is eligible for reappointment. 2, that the term should apply to all members of the courts martial and not limited to the chairperson as proposed in the bill. Appeals from decisions of courts martial. The bill permits unit court martial to the division courts martial to the general courts martial, and from the general court martial to the Court of Appeal, with the Supreme Court as the final appellate court. The Attorney General explained that since the High Court lacks appellate jurisdiction over capital offences, appeals for such cases must lay directly to the Court of Appeal. The committee agreed with this reasoning, but raised concerns about the practicability of requiring officers and soldiers in remote areas to travel to Kampala for the General Court Martial appeals. This could be costly and could hinder access to justice. Additionally, the right to appeal where the aggrieved party is dissatisfied with the unit court-martial decision has only right to appeals, while a division court-martial decision can be appealed to the Supreme Court where viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court-martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honorable Speaker and honorable colleagues, we recommend the following. 1, that appeals from the unit court-martials should lay with the division court-martial. 2, the decisions of a unit or division court-martial on matters of law and facts should be open to challenge. That appeals from decisions of the general court-martial should lay with the Court of Appeal as proposed in the bill. 4, proposed section 2272 should be deleted and section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee acknowledges vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and territorial integrity of Uganda. In light of evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defense Forces, and in particular provide for the organs and structures of UPDF. Section 2 of the UPDF Act, Cap 330, provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation or unclear classifications, e.g. informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that the decentralization of the pension authority to the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service.
Madam Speaker, I'm rising on point of order. Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here when, is it in order for them to continue defying the ruling that you made, that this front seat be reserved for the members? Is it in order?
Honorable Wilson, continue.
Thank you. Right Honorable Speaker, I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
listen to the
introduces, Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, the Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian, addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The Joint Committee therefore recommends that 1. Establishment and operationalization of a dedicated health care service for the defense personnel as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classifications. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and the categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore recommend that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that a provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion, Right Honorable Speaker and Honorable colleagues. We therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached hereto and any other modifications the House may propose and approve. Right Honorable Speaker and Honorable colleagues, I beg to report.
Thank you. Thank you so much. Thank you. As you informed that we have a minority report from Junior, Okot Moses Junior. Please present your report. Go to areas of dissent.
I'm not talking.
Habib, you extend, you're disturbing Junior.
The Right Honourable Speaker and members, I move to present the minority report. But prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the Joint Committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner haphazardly reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right Honourable Speaker, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide. Okay.
While I finish making my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
Just finish and wait.
There is an order.
Thank you very much, Right Honourable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and it is only him who is illogical in this House when we represent our different constituencies? Is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with the reason and with the logic. And these are honorable members of Parliament. So whenever there is a debate here, it is done with the logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honourable Speaker, I withdraw.
Honourable members, allow me to chair the House. Junior has withdrawn the statement and will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honourable members of Parliament. Yes, Junior?
Right
You
Honourable
go and
Speaker.
look for them.
Right Honourable Speaker.
Junior, continue.
In Right Honourable Speaker, if the House may please, I'll read.
Read your report.
Right Honourable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defence and Internal Affairs on the decision of the majority in respect of Uganda People's Defence Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025. And in accordance with Rules 134 and 200 referred Joint Committee of Parliamentary Legal Affairs and that of Defense for scrutiny. The object of the bill is to amend the Uganda People's Defense Force Act, Cap 330, to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9, by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabazaruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016, as a locus classicus case in addition to other authorities. The point of dissent are: 1, contravention of the Constitution; 2, illegality in military trial; 3, offending the doctrine of separation of power; 4, lack of public participation; 5, unconstitutional expansion of the military court's jurisdiction; 6, constitutional limitation on Parliament's power; 7, lack of independence and impartiality of the court-martial; 8, non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honourable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the defense force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the defense force which is in active service in any place; B, where he or she has agreed to be subject to military law; C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the defense force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law; D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. the offenses below. 1. Murder. 2. Aggravated robbery. 3. Kidnap with intent to murder. Treason, misprision of treason, or cattle rustling. E. Where the person without authority is found in possession of or sells or wears a uniform of the defense forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the defense force prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of this Act. G. Where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the defense force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28.1, 44C, 128.1 of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It is thereby contradicting Article 28.2 and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that to the courts such assistance as may be required to ensure effectiveness of the courts. See Article 28.2 and 3 of the Constitution. This action amounts to contempt of the Supreme Court, which is criminal. Right Honorable Speaker, in a locus classicus case,
do you have to ask a dissent to add a dissent, Parliament? Must you add dissent? Nobody doubts that we are dissent.
So you oblige.
Expand the word dissent.
In the locus classicus case of Liange versus the Queen, 1967, the Sri Lanka Parliament passed a retrospective law affecting the trial of individual accused of attempted coup. The Privy Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honorable Speaker, rather, and colleagues, there were other authorities that were cited year after to persuade the House. I urge members to peruse through while I go to deal with the second area of dissent. The second area of dissent is illegality in military trials. Your Honor, Right Honorable Speaker, the question of illegality in military trial is ably canvassed by the Supreme Court in the case of Michael Kabaziruka in the above case. Owindolo CJ, in his lead judgment at page 180 and to 185, add this to say, Your Right Honourable Speaker. There are also other vital reasons militating against trials of persons subject to military law for all offences. These courts has previously held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offences. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honourable Court Junior.
Yes, Your Honor.
Honourable Justice, Chief Justice Owejidolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the court first.
Speaker. And if I may proceed from where I had stopped, Right Honourable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honourable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against trials of persons subject to military law for all offences. This court has previously held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on a court-martial jurisdiction to try such an offence. For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well. And also it would be self-defeating for an offence similar to terrorism to be created under the UPDF Act and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still correct position of the law, and where jurisdiction is expressly excluded or where the DPP's consent is a prerequisite, the court-martial are not competent to handle that matter, so excluded irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offences, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases beyond mere provisions in the UPDF Act and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court-Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where he held that the General Court-Martial is subordinate but not lower than the Court-Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court-martials as subordinate courts created under Article 129(1)D can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court-martials of offences within the jurisdiction of the court-martial is unconstitutional under Article 28(1), 44C, 128(1), 129(d). Close quote. The general rule is that ordinary courts alone have jurisdiction to try civilians. The Supreme Court was unable to find any rational justifiable link between the need to maintain discipline in the army or maintenance of security of Ugandan borders and trials of civilians in the military court tribunals generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179(1), 2, and now 171(1) and 2 of the UPDF Act.
Is it 171 or 177(1) and 2?
179(1) and then 1 and 2, and then 177(1) and 2 of the UPDF Act. Read together with 197(2) and now 197(2), which grants subordinate military courts jurisdiction over capital offences, contravenes Article 129(1)D and Article 126(1) of the Constitution. Hence, they are unconstitutional. The provisions of Section 119, 1I and G, now 117(1) and G, is unconstitutional to the extent that it permits trials in court-martials of civilians who allegedly aided and abetted the commission of service offences or ordinary criminal offences in which a person subject to military law is a principal offender. Right Honorable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2, the minority observed that military courts can only have jurisdiction in relation to specific class or category of persons and specific offenses which ordinary courts are not in position to try. 3, the jurisdiction of the court-martial can only extend to cases reserved for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4, military courts cannot have jurisdiction of offenses which require the consent of the DPP. The consent of the DPP. 5, civilians cannot commit or be tried for service offenses even when they abet or aid the commission of offenses. 6, where civilian and military personnel have committed a crime other than a service offense, both be tried in civil courts. In 7, Parliament cannot duplicate offenses prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent, independent, fair, impartial court or a tribunal with a decision of the Supreme Court. The trial of persons with offenses within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes, therefore, without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honorable Speaker and members, let me conclude on this note. Court martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. By Justice Catherine Bamugemere, Justice of the Supreme Court, at page 41 of our judgment. Colleagues, members of Parliament, having appreciated that the second area of dissent has been appreciated, I would go to
Go to the third area of dissent.
Your Honor, Right Honorable Speaker, offending the doctrine of separation of powers. Modern democracies are typically organized around three branches of government, each playing a crucial and distinctive role. Adjudication in particular is a function and a preserve of the judicial branch of government. Overriding or intrusion would in any of the other two would inevitably offend the Constitution. The judgment of the Supreme Court covers situations where military under the UPDF Act may depart from this position by only in a very exceptional circumstance that are consistent with demonstrable justification. The Chief Justice at page 78 to 79, quoting Nalwairo in his work, Improving the Administration of Justice by Military Court in Africa, an appraisal of the jurisprudence on human and people's rights, 2019. Held that a host of authorities, held that separations of power helps to provide sufficient safeguard to ensure fair hearing by instruments enunciated by the law on independence and impartiality of the court-martial, such as cardinal and core to the administration of justice. The minority are of the view that granting the military, through court-martial, the unlimited power to try persons with offenses beyond disciplinary ones would be a violation to the doctrine of separation of power, beyond its function envisaged in Article 209 of the Constitution. Article 210 of the Constitution, pursuant to which the UPDF was enacted, did not envisage the establishment of a military and judicial function. Such an extension, therefore, can only be handwork of a overzealous but mischievous stretch imagination, rooted, brewed, and bred in imperfection by proposing an amendment which doesn't meet the test of legitimacy, and we invite Parliament to reject this bill to this extent. 3-0, impartiality and independence of the courts. Right Honorable Speaker and colleagues, members of Parliament, the impartiality and independence are not decorative ideals. They are constitutional imperatives grounded on Article 28 of the Constitution, the right to a fair hearing, and Article 128 of the Constitution, independence of the judiciary. Military courts, as a creature of statutes, are subordinate to the constitutional principles and are bound by these standards. Article 128(1) of the Constitution also imposes a requirement as to the objective of the independence of the or tribunals, exercising judicial powers as a safeguard to a fair hearing. It states that in the exercise of judicial powers, the courts shall be independent and shall not be subject to the control or direction of any person or authority. The bill in clauses 35, 36, 38, and 45 provides for various amendments to the UPDF Act, specifically to the provisions establishing courts martial. It creates the following court-martials, a unit court-martial, divisions court-martial, the general court-martial. The bill removes the following courts and trial processes. A, the commanding officer or officer commanding. 2B, trial by superior authority. C, court-martial, court of appeal. D, field court-martial. E, summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021 Attorney General versus Michael Kabazaruka as far as independence and impartiality is concerned. Colleagues, I am persuaded to take you further to our next point of dissent, appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to these submissions because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes Section 117A. Proposed Section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. B, it extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offenses which ordinary courts are in position to try. C, the bill also extends military courts to cases reserved for specialized courts such as the High Court. D, the bill extends service offenses to civilians. Minority cautions Parliament that the Supreme Court directed Parliament not to duplicate offenses prescribed in other acts of Parliament and introduce them in the UPDF Act, where therefore recommend that the same be rejected. 4-0, lack of public participation. The Constitution in Article 38(1) and 2 thereof reaffirms the right of every citizen to participate in the affairs of government in accordance with the law. This includes engaging peaceful activities to influence the policy of government. On Tuesday, 13th of May, the Clerk of Parliament issued notice inviting the public to submit their views.
Jogenda maso n'okubanga otulabira nkusaba busabi video yongera okubeera ng'ogiwaka like yongera okubeera ng'osharinga live video eno osobola okubeera nga ate omanyisa n'oyo abadde tamanyi nti ebigenda maaso mu nsi ye Parliament bwetyo bwegenda maaso n'okubanga ate etambuza ensonga zino. Ekigenda maaso mu kaseera kano kwe kubeera nti omubaka ababaka abenjawulo bagenda ku floor ne batandika okubanga bawa endowooza yaabwe okusinziira ku tteeka lino oba Ammendment Bill ya 2025 eya UPDF Act. Ate ababaka abasobodde okubeera nga ate badduka mu Parliament oba ababaka abali ku ludda oluvuganya bo basobodde okugenda mu official leader of opposition Joel Senyonyi era nga mu kiseera kino nabo bali live. Osobola okugenda mu video zaffe endala bw'obanga oyagala okulaba leader of opposition byayogera. Of course byagenda maaso n'okubanga ayogera kwe condemning ebikolwa bya Parliament byegezaako okukola ebikontana n'ebyo bannayuganda bye baagala and of course n'amateeka aganyigiriza okwosaako n'okwagala okukomyayo abaana b'abannayuganda mu nkomyo. Then ababaka buli omu ndowooza tugenda muwa obudde tumuwulirize nga bw'ali naye nga Joel Ssenyonyi leader of opposition waali agenda maaso n'okubanga asensula ensonga n'ababaka bonna nga bwe bafulumye palamenti abali ku ludda oluvuganya. Palamenti mu kaseera kano ejjuddemu babaka ba NRM n'ababaka abalala ngera bw'omanyi nti tebeebulizaamu. Yes, bo gye bali bagenda maaso nabo n'okubanga batambuza ekintu kyabwe mu ngeri gye baagala okuba nti abakitambuzaamu. Then ensonga endala omusango gwa Council Luyimbazi Nalukoola gukyagenda maaso era guli live wano ku Mukutu Vic exclusive stream kweri osobola okugenda nagwo n'olaba. Kati naawo abamu ku babaka bagezaako okulaga speaker ebibi ebigenda maaso muki mu nnongosereza zino ze baakoze. So nga ate ababaka abalala bagezaako okulaga speaker nti yes etteeka lino oba ennongosereza zino zeetaagibwa okuba nga ziyisibwa olw'ensonga ze bagenda okubeera nga bakola ki nga bamenya. Sinakindi n'abo abalala ensonga ze bakoze ki ensonga ze bamenye. So ekigenda maaso mu palamenti kye kino tugenda kuba tukuwa enteekateeka yonna ku tteeka lya UPDF erya palamenti lyegenda maaso n'okubaganyako ebirowoozo mu kiseera kino. Abantu banyiivu, yes, mu kiseera kino abantu banyiivu. Kankuzeewo mu palamenti ate osobola okuba ng'olaba ebiriyo mu mbeera emu oba mu mbeera endala.
And removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts, and cannot override the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies exclusively with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much. Honourable members, there are two minority reports. Not so, Chair. There are two minority reports.
Right.
Second one, I am not aware, and it offends the rules of procedure, Right Honourable Speaker.
Yes.
The Right Honourable Speaker, according to the official information we have, is that the opposition are officially boycotting this sitting. I would wonder how my colleagues are masquerading here.
Honourable. Honourable members, opposition is in the house. Opposition is in the house. I see Honourable Kelo, Honourable Court, Honourable Olanya, Honourable Santa, Honourable Duru, who has ably presented a report, Honourable Namanya. Honourable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here. But I've just read, it is a minority report of the Honourable Jonathan Odur. I was not informed what it was, but I've just read and realized it is
The man did not attend.
After all, it's a minority. It's a minority.
Yes, Fox.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honorable Dole, which the chair said was not given to him.
But, Right Honorable Speaker.
Honorable, yes, yes, Honorable Minister.
Right Honorable Speaker, since NRM believes in democracy, we should allow Honorable Dole present to the House.
Honorable Chris.
Thank you very much, Right Honorable Speaker. We make the rules ourselves as the Parliament, and we must respect our own rules. Everybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be seen to be suffocating in a member. Let Honorable Dole come up with his report and give us a summary of his report, his areas of dissent. Let him do it.
Thank you. Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning, I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk to Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the shadows approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme Case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126.1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament, and on the contested matters, the Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by one Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it's not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court-martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows: Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two: one in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemerere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this day, date, and year will go down as the official birthday of the dreaded military dictatorship in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names, in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Aneta Mao, Colonel retired Dr. Kiza Warren Besige.
Honorable, I've never wished to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one.
Please, my name is not for jokes. I never want.
Yes,
Honorable, it is my name.
Madam,
please remove it.
Yes, this is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to make.
Withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
Withdraw. I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record has it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda in light of the case of the Attorney General versus Michael K. Constitutional Appeal number 2 of 2021. The next point is dissent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offenses, herein called military, disciplinary, or service offenses, stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5. Whether it is constitutional for persons subject to military law to be tried in the court-martial for offences outside the UPDF, for civilians to be tried by the court-martial as principle for offences under sections 1191H of the UPDF Act. Yet all those also exist in the civilian, each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or a mere tribunal. In answering this question, Right Honourable Speaker, which answer was agreeable to the rest of the panel, Honourable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. One is that the Supreme Court is a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecution, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A, members of the General Court-Martial must be persons with requisite legal qualifications. B, the members of the General Court-Martial should be independent of the command and have security of tenure. C, there should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D, the convening authority must lie with the General Court-Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closes. Attorney General further writes, Sections 2, 179, 1191H and G, now respectively 177, 10X, 1171H and G of the UPDF Act are unconstitutional, since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8 and 9 by the court is that civilians cannot be tried in military courts. Our understanding of these declarations 7, 8 and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 1193 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honourable Speaker, that in both the original constitutional petition, number 45, of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court and in the Constitutional Appeal number 2 of 2021, the Attorney General versus Honorable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even Parliament expect the same learned Attorney General to again go back to the Constitutional Court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kiwanuka, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General Senior Counsel William Biaruhanga, I'm reliably informed, asked to be excused from executing the role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this role. He had the energy to marry even a new young wife. So it is really burdensome to be an Attorney General.
He has nothing. I mean, what's wrong with marrying a wife?
Finding. Huh? I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify enactment to provide for trial of non-military offenses in the court-martial and found by the Supreme Court are established legally. Hence, there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already re-established it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court's finding, where he held that the General Court-Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Ghana, 8th edition, subordinate means placement in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the word subordinate, all courts-martials are subordinate courts created under Article 129, 1, sub-article D, and can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than the High Court is contradictory and has potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them jurisdiction to handle capital offenses, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129.1, the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently, by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-Article 1, and listed either in, you can reflect, in Clause 1C with the High Court, meaning at the same level, or immediately before Clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, sub-Article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honourable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honourable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeal sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offences in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service stroke military offences must be before civilian courts. In other words, the current civilian courts, Magistrates Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief, a question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offences proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offences. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and will deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers, if we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power for 39 years and who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain on the incompetence, weakness in the civil courts to handle any case in Uganda? If the minority was granted more time, Right Honourable Speaker, it would have produced on record all cases of murder, aggravated robberies, terrorism proposed in the bill against accused persons, including military personnel, which has been successfully prosecuted in the civilian courts. By the time of writing this report, Madam Speaker, I had not known that yesterday the High Court convicted a former soldier, a militant, of an offense. That further demonstrates and strengthens my argument that actually the civilian courts right now can convict, try and convict, murder, aggravated robbery, etc. The minority invites the attention of members, especially those familiar with court papers, to reflect on the proposal of the Chief Justice, which captures the spirit of the advisory orders by the Chief Justice as follows. I have put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial stroke military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offenses committed by the military person. The next point of the dissent is on limited or exceptional circumstances, as has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the Constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be constitution in force. Two, courts of law have no capacity to try the offenses. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda? And why not deal with the root causes of it all, which is the security of the judicial officers, rather than recourse to the courts martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make...
At least not everybody is foolish.
No, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans... Madam Speaker, to make all Ugandans liable for trial in the military justice system, first of
for our teams. Ignite your color with Plascon, proud partner of Uganda Sports.
Madam Speaker,
color
for
your
the
world.
record, this morning I
That's
made
me
a
having
phone
the
call to the
worst
chairman
day
of Legal
ever.
and
But
Parliamentary
then I saw
Affairs
them,
Committee,
and I knew my best is.
and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk to Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me to present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the shadows approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1.
ebifa sides eyo genda bitegera bulungi ku mukutu Viki exclusive. Nkyakwebaza gwena ali gyoli era nga okyekuumidde ku mukutu Viki exclusive okusobola okuba nga ofuna n'okumanya updates zonna etteeka oba ebbago ery'etteeka lya UPDF Act likyagenda maaso n'okuba nga likubaganyizibwako ebirowoozo mu Parliament. Ababaka bangi buli omu avaayo endowooza awaye, naye katulabe olunaku olwaleero lunaazibira nga kiki bannansi era bannayuganda kye bagenda okuba nti beebaza ababaka baabwe okuba nga babakolera. Yes, ebigambo bingi mu Parliament okwosaako n'ebweru waalyo, era nga ababaka ab'oludda oluvuganya bo bagambye ffe bino tetugenda kubanga tubiddamu, automatically bo ne bakivaamu era ne bagenda ne badressinga eggwanga ne balitegeeza nti mumanyi ebiriwo mu kiseera kino ffe tetukkiriziganya nabyo olw'ensonga bigenda kunyigiriza bannansi, bigenda kunyigiriza bannayuganda. Tetulina ngeri yakuddayo wansi ku ground ate nga tutuno tusemberedde akalulu atunyonyole abakama baffe nti kaakati ate mumanyi bwe twali mu Parliament twakola ABCD ku nsonga y'okusibya abaana bamwe nga babasavingira babasalira ebibonerezo mu kooti y'amagye oba nga babavunaanira mu kooti z'amagye. So abamu ku babaka bakivuddemu, so ate abalala ne bagamba ffe katutuule tuwulire oba oliawo naffe tugatteko endowooza yaffe. So eyo yembeera mu kiseera kino egenda maaso ate mu babaka ba Parliament mu Parliament nga bagezaako okuba nga bateesa. Tugenda kukomawo n'ekitundu kyaffe ekirala ekyokusatu. Kino kibadde ekitundu kyakubiri. Parliament yasoose negenda mu kuwummulamu okwasoose, then egenzeeko mu kuwummulamu omulundi ogwokubiri. Tugenda kuba nga tukomawo mu session egenda okubeera ey'okusatu nga ate twongera okumanya n'okulaba kiki ekigenda okuva mu zeebiraka. Etteeka ddyo likyagenda maaso n'okuba nga likubaganyizibwako ebirowoozo era nga mu kaseera kano kyekirindiriddwa okuwulirwa nga kifuluma eri Parliament nti ddala kituufu ababaka bagenda twegaana omulundi gumu oba ababaka bagenda kubeera nga bazamba Uganda essuubi mu mbeera emu oba mu mbeera endala. Mama Ricky ongamba mbeko bamemba ba NRM bangi era house almost yekubyeko bamemba ba NRM, naye era tewerabira ababaka abamu tebasobodde kubeera nga bajja mu Parliament olwaleero. Okusinziira ku njuyi zombi bwe nabadde neetegereza ababaka b'oludda oluvuganya mu Parliament abali ku opposition babadde bafuluma n'okuyingira Parliament nga ndaba waliwo ababaka abamu besirabawo, nga ndaba waliwo abamisi nga bwe ngenza okwetegereza Parliament engeri gye badde tuddemu olunaku olwaleero nga abamu ku babaka ba NRM still tebasobodde kubanga bajja, naye nga percentage ennene ku ludda olwa NRM ababaka babadde weebali era nga batudde entende n'okuba nti basobola okuvaayo ne bawa endowooza zaabwe okusinziira ku bbago ery'etteeka nga bwe ligenda mu maaso mu kiseera kino. So just subscribing ku mukutu wekumire wano osobola okubeera ng'ofuna updates zonna. Mu kooti Edi Mutwe aleeteddwa ne bagenda mu kuwummulamuko n'endowooza mu ddakiika mpaawo kaaga ku mukutu Viki exclusive nawo tugenda kubeera nga tujja okuba nti tukutuusaako ebifa sides zeeyo ate mu kooti. So now munzikirize as of now mbeere nga nkomako wano mwenda kuba nkomawo nga Parliament ekomyewo ate nange nfunekoko ku lwendo lw'otuzzi ate mukama abansinkanye mu ddakiika eziddako tebagenda kubanga bawummula okumala akabanga akanene. Muli bantu bangi asisobola kuyitamu mu buli sekinomu Trishia Kila Yekela nontikira. Aha, Paulo Kwoli, Deborah Kwoli, Tina Kwoli, the African Lion Kwoli, Harriet Kwoli, the Has Kwoli, Mama Ricky Nkuzemu, muli bangi, muli bayitirivu, Kyagulanyi Stivo, na buli muntu yenna Abe, Geoffrey, buli muntu ali ku mukutu Viki exclusive, ekyo kyokola ky'amaanyi nnyo nnyini ddala, era weebale kubeera nga weekuumirako. Yakatweyungako osobola okuhitinga subscribe button yawo wansi, oba osobola okwegatta buterevu ku conversation eno. Simanyi mwe kiki mulowooza ababaka bamwe kye bagenda okuba nga bateeka ku flow at the end of the day, naye osobola okumpa endowoozayo ate nemba nga ngisomera bannayuganda abalala abakatwegattako oba abeekuumidde ku mukutu Viki exclusive. Yo parliament egenzeko ko mu luwummula katiri nnyo, just ka break, naye egenda kubanga ekomawo. Explain these bills for me. Oyagala ababaka bakunnyonnyole ebbago lino oba etteeka lino, teri mubaka agenda kunnyonnyola buwaayiro bwonna buli mu tteeka. Ekyo mukkirize. Omubaka wo tajjeeyo ku ground n'akugamba mbu ebbago nalyetegereza kawaayiro ku kawaayiro ne nditunulamu nga wano teritukosa nga wano litukosa. Ekimu ku bigendererwa ebya pushinze etteeka lino oba ebbago lino okubanga lidduka ku speed ey'amaanyi is just because ababaka baffe, ababaka bammwe baalya millions 100, babawa ssente, kati waliwo speed mu buli kimu ekigenda maaso n'okubanga kikola ki, na buli kimu ekigenda maaso n'okubanga kikolwa. So now gwe omubaka wo mu questioning akuwe answer, netakuwa answer egamba nti yetegereza buli kawaayiro era akakunnyonnyole. Yes, ojja kubeera otegererawo nti oyo omubaka wo agezaako kubaako ngeri gyakuperereza, osobola okumulabawo ate mu kalulu ke tugendamu aka 2026. Honorable w'ekitiibwa and Honorable Ssemujju Nganda have shown that they are members of parliament this term. Honorable Ssemujju Nganda n'ekintu abadde akikutte. Ekintu abadde akikutte. Speaker yakubiriza olwaleero olutuula lwaleero taluwaddeemu muntu mulala kumutuuliramu, ensonga bwetyo bwetambudde. So nga ate ababaka abamu bettanda bakubeera nga tulabako tuli kubanga twebuuza mayitire gaabwe nti ate bo olwaleero batukoze batya. So tugezaako kubanga tumanya. So nga Uganda bwetyo bwetutambuza, mukkirize nsooke mbeerekereze ate then ngenda kuba nkomawo mu mbeera emu oba mu mbeera endala tusinkane mu kitundu ekigenda okuddako nga parliament